All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save this state and this honorable court. Be seated.
Good afternoon and welcome to the Court of Appeals. My name is John Tyson. Your panel this afternoon consists to my right, Judge Lucy Inman, and to my left, Judge John Arrowwood. We have one case for argument on the docket today, case 2605, Mobile Imaging versus North Carolina Department of Health and Human Services. We'd like to welcome the many interns who are here in court today. I know that you represent a lot of chambers and your opportunities to see oral arguments has probably been limited, so we hope you find the oral arguments enjoyable, and we want to thank you for what you do for the court. Are there any preliminary matters before we get started? Okay. Does the appellant wish to reserve time?
I do, Your Honor. 5 minutes.
5 minutes. Okay, thank you. The panel has, we've received information from our clerk that everybody in the room has been vaccinated, and the panel is agreeable for everyone to remove their mask if they would prefer that. Okay? Hearing nothing else, we will hear from the appellant.
Good afternoon, Your Honors, and may it please the court. My name is Lee Whitman. I'm with the Raleigh, North Carolina law firm Wyrick, Robbins, Yates & Ponton, LLP. It is my pleasure to represent Mobile Imaging Partners of North Carolina, who is the appellant in this case. That is a joint venture, as you're probably aware from the briefs, between Alliance Healthcare Services and the UNC Rockingham Hospital.
But now, is it correct that the alliance doesn't happen unless you get the con?
Yes, sir, Your Honor. Judge Arrowwood, that's absolutely correct. The entity has been created, Mobile Imaging Partners of North Carolina, and pursuant to the joint venture agreement, if and when a certificate of need should be awarded by the agency or by this court, that will self-execute, and UNC Rockingham will become a 49% owner in this entity. That is correct.
So to follow up, as we sit today, Alliance is the one who is the appellant before the court?
Well, MIPNIC is the appellant and the applicant in this case. It is 100% owned by Alliance at this time, Your Honor.
All right. Okay.
And as I said, if we were successful in this appeal and we were to receive the certificate of need for the mobile PET scanner, the joint venture agreement would self-execute, and UNC Rockingham would become a 49% owner in the joint venture.
Okay, thank you.
As an initial matter, Your Honors, I would like to thank the court for granting oral argument in this case. We know that you don't have to do that because the outcome of this case will affect public policy and healthcare planning as we go forward for any health service that has a statewide service area. Additionally, if the court may not be aware, the 2021 State Medical Facilities Plan, or what we refer to in our industry as the SMFP, contains another need determination for one mobile PET scanner statewide. So the court's opinion in this case will be very instructive to all those of us that practice healthcare, the healthcare consultants. Everybody will be certainly looking to how Your Honors resolve this case, as there is another mobile PET scanner in the plan for this year, and those applications are due October 15th.
Mr. Whitman, am I correct that there are currently 3 existing mobile scanners operating and that your client operates 2 of those, and Novant Health has a 3rd scanner, but it is limited only to Novant Health facilities? Is that correct?
That's almost correct, Your Honor. I would say Alliance, who is the 100% owner of MIPNIC right now and will be the 51% owner, it has the first 2 scanners, as Your Honor mentioned. That's Alliance 1 and Alliance 2. That's how that's tracked in the State Medical Facilities Plan. And that was the result of a single review that happened back in 2002. The Alliance 1 scanner was dedicated to serve the western portion of North Carolina, and the Alliance 2 scanner served the eastern portion. That's how all of this got started. Subsequently, in 2012-13 timeframe, Novant filed a petition It was not a need determination, but they filed a petition pursuant to a policy that the Certificate of Need section has, and they were able to convert a fixed pet, those are the ones that stay at the hospitals, don't move, into a mobile pet with the condition that they only serve Novant hospitals. So that would be the 3 scanners, Your Honor.
If I can just ask you a couple questions about what you already sort of got to the core of this
Yes, ma'am.
case about statewide
Yes.
and the different interpretations of that word.
Right.
The legislature has not been helpful to us in this regard. If you can just sum up how the 2 different interpretation, that is anywhere in the state,
Right.
throughout the state, you talked about huge public policy implications, but just to make sure we're on the same page about what you think, and then related to that, you've asserted that we should not give any deference to DHHS's ruling that Insight met the statewide need determination.
Yes.
And I would just like to,
Of course. I'll be glad
Follow
to
up that.
address all of that. There were a number of questions in there, and I'll see if I
yes.
I'll see
that's
if I
fine.
can get them in order, Judge Inman.
No order is needed, just
Because
to let you know what.
The statewide need determination is a huge issue in this case. You would not know that if you read the final decision, but it was a large portion of this case. If you read the transcript and look at the documentary evidence that was admitted, this was a huge issue. Why? Because we'll get to it. The rescission letter that was a big issue in this case is not the only reason that we contend Insight is non-conforming with Criterion 1. Really the bigger reason, and the reason that affects public policy and healthcare planning, is that because we asserted during the trial they don't meet Criterion 1 because the proposal to serve only 2 rural hospitals in the westernmost portion of the state, as a matter of law, does not meet the statewide need determination identified by the State Health Coordinating Council, the SHIC, in the SMFP. So to answer your question, Judge Inman, how did we get here? The 2018 SMFP identified a need for 1 mobile PET scanner statewide. That's what it said. And it indicated, and obviously the SMFP is in the record, it indicated that the need for the service was statewide. That's the plain language utilized by the SHIC. When we got to the OAH to try the case, the position that was offered at that time by Insight was, well, our application does conform to Criterion 1 because statewide means anywhere in the state. We could plop it down the farthest in Murphy, North Carolina, it would be complying. We said respectfully, Your Honor, to the ALJ, we disagree with that. That is contrary to the stated word in the SMFP.
But it's not contrary to what the department says it means, is it?
Your Honor, Judge Earwood, no, and that's what's cited by the ALJ, because Ms. Frazzoni, not surprisingly at the trial, said, well, I interpret statewide to mean anywhere in the state, and she's the chief of the CON section.
And why should we not give the agency deference here? Because if it's an interpretation of rules, it's deference. If it's an interpretation of statute, it's deference. Why should it not be deference here?
That's the exact right question, Your Honor, and the answer is because the case law of this state clearly dictates that agency decisions will only be afforded deference, right, if they are reasonable, based upon a proper construction of the statute, and are a long-standing and consistently applied. None of that, Your Honor, respectfully, can be associated with this decision. Now, Ms. Frazzoni had been chief of the Certificate of Need section for 25 years, but she had never done a mobile pet review, statewide mobile pet review. There is no long-standing and consistent interpretation that that means anywhere in the state.
Well, have there ever been any determination about what statewide means in any other sense other than a pet?
If there has been, Your Honor, I certainly can't say there hasn't. It was not offered as evidence in this case. It's not in the record.
Going back to I understand this need was determined after 18 years, not
Yes.
counting the Nova conversion.
That's correct.
When your client got the original certificate for the 2,
Yes.
were they approved at the same time
Yes.
under the 2002 STMF?
SMFP, yes, Your
Yes.
Honor. I believe that's accurate. I may be incorrect about that, but my understanding is that that happened at the same time. Yes, sir.
So was there criteria in the 2002 con that said that you must put one in the east and you must put one in the west?
I don't remember what the specific need was at that time, but clearly from the decision that was issued in 2002, Alliance 1 was to serve the western part of the state, and Alliance 2 scanner was to serve the eastern part of the state, which I also submit to the court shows statewide coverage.
But isn't that an internal determination as opposed to being required by the agency or under the terms of the con?
Well, I believe that that was determined by the State Health Coordinating Council, Your Honor, who identified a need for mobile pet service, and people could apply for it. And that was, the agency was taking that, as they did in this case. You take what's in the SMFP, you can apply for the service. If more than one party applies for it, which is what occurred here, you have a competitive review after the agency looks at all the applications to determine if you're conforming with all the statutory review criteria. And here, 3 of the 4 applicants, as Novant applied, MIPNet applied, Insight applied, and a 4th applicant applied, but that applicant was not deemed to be conforming with statutory review criteria. So at that point, only the other 3 applicants were eligible to receive this certificate of need.
Let me refine my question a little
Okay.
bit. Going back to the approval in 2002.
Yes, sir.
To the 2 that your client's currently operating, was there anything in that approval that required you to station one in the east and one in the west, or was that an internal decision your client made?
No, I believe it's the former, Your Honor. It was specifically authorized and instructed by the SHIC and/or the certificate of need in granting the CON. And when CONs are issued, they're always with conditions from the agency. It was dictated that Alliance 1 would serve the west and Alliance 2 would serve the east.
And what about the middle of the state with the Piedmont?
Well, the state was basically split in half. With regard, when I say west, if you start in Greensboro, Alliance 1 served west of Greensboro and Alliance 2 served east.
Do you overlap with Novant's mobile unit?
I'm sure that we do, Your Honor. Alliance 1 and 2 would overlap. I'm just not sure where Novant operates its 3rd mobile pad. It's limited only to Novant hospitals, which are mainly in the western part of the state, but I also know they have one on the coast. So,
Well, if Novant's hospitals are limited, mainly in the western part of the state,
Right.
one on the coast, is that statewide? I mean, they're not in all 100 counties?
right. Well, Your Honor, I don't know that it's statewide, and we've never came forward in the trial with the position that statewide means 100 counties. The service area, we contend, and I want to answer Judge Earwood's really good question about why don't we give deference to this, because there's multiple reasons. Our case law, Your Honor, has said, Judge Earwood, that the agency interpretation cannot be contrary to the plain language of the statute. That's the Hospice of Greensboro case from 2007 that both Mr. Hewitt and I were in. This court has also held that an agency interpretation that is in direct conflict with the clear intent and purpose of the act will not be upheld. That is the AHNC owner case from 2015, which Mr. Hewitt and I were also in together. And the reason that's important here, because I want to answer Judge Earwood's question as to why shouldn't we give deference here. One, the interpretation is contrary to the plain statement in the SMFP that it be statewide. Second, what is the origin, Your Honors, of this need determination? The origin is this. Alliance 1 and Alliance 2 have been historically overutilized since 2012. So when the 2018 SMFP was issued, Alliance 1 was at 135% capacity. Alliance 2 was at 140% capacity statewide. So it was the overutilization of those 2 scanners statewide that created the need. And I would also respectfully submit, Judge Earwood, that if you take the interpretation offered by the agency and Insight in this case, the word statewide is not needed. Their argument is that, well, what that really means, what the SHIC really meant to say is, we need one more PET scanner.
Let me ask you this. Since you got the original 2 in 2002, have you not expanded your service area over time?
We have, Your Honor.
So you are covering a wider area now than you did in 2002.
That's absolutely true.
Couldn't we assume that, or presume that Insight would do the same thing?
You could presume that, but if you do presume that, Your Honor, this gets to my question. I think Judge Inman asked me this. I've raised the point, and I stand by this point, that this case is very important to public policy and healthcare planning. To get that certificate of need, you have to come in and show that your proposal meets the need in the SMFP, and you have to show you're consistent with the statutory criterion, okay, in 131E, 183A. To do that, because they ended up with only 2 host sites, and they could have had as many host sites as they wanted, because they only ended up with 2, the numbers that they put in this application, the projections for utilization, the projections for financials, the number of scans they say will occur at each of these 2 little hospitals in Western North Carolina to satisfy the performance criteria under the CON law is not reasonable, and it's not adequately supported. And the agency failed, this record demonstrates, to assess that during the review, and the ALJ ignored the evidence presented at trial that this proposal from Insight is not reasonable and cannot be reasonably supported. And what the Britthaven case tells us is, well, the ALJ can only look at evidence that was available to the agency at the time it made the decision to determine whether the agency was reasonable.
Are we not bound by that same record on appeal?
Yeah, absolutely. Absolutely, and that's what I'm going to get to, Your Honor.
So the standard of review, we're not reviewing the agency's decision, we're actually reviewing the ALJ's decision.
That's correct.
And can you walk us through what this court's role is in reviewing the ALJ?
Absolutely, because there's some competing arguments in the briefs here regarding the standard of review. The standard of review here, an appeal from a final decision from the agency, is controlled by North Carolina General Statute 150B 51, and specifically subsection C. And the distinction drawn there by the legislature is, if you're alleging an error of law, an incorrect interpretation or application of law, which that's what we're doing here, that's a de novo standard. If you're alleging that the decision by the ALJ was arbitrary and capricious, then it's going to be what's called the whole record test, right? And that's what they argue, obviously, because that's a much harder burden for us to satisfy. But respectfully, Your Honors, look at what we've alleged. Under North Carolina law, the substantive nature of the error alleged drives the standard of review. We have alleged that the agency and also the ALJ failed to correctly interpret and apply statutes and rules and the SMFP. Thus, we respectfully contest.
Well, it's the SMFP that you're specifically contending they didn't apply, isn't that correct?
Yes, Your Honor, but that's a part of it. 131E 183 is the statutory review criterion, and criterion 1, which we believe this whole case can be decided on criterion 1, says that your proposal as an applicant must meet 2 things, not just the need determination in the SMFP, but also the policies that underlie it. You got to do both.
But at base, it's the SMFP is what you're contending they misinterpreted. Is that not correct?
Yes, but you only get there, Your Honor, if they misinterpreted criterion 1, because criterion 1 says that an applicant has to show in their application how they meet not just the need determination in the SMFP, but also the underlying policies, and they did neither here. The need was clearly driven by a statewide overutilization of pets. Their proposal doesn't address statewide.
Let me ask you this, Mr. Whitman. The application only required 2 letters of support, correct?
That is correct,
From
Your
2
Honor.
sites.
That's correct.
So if the application itself for the con only required 2 sites to support it,
Right.
isn't that indicative that they considered 2 letters of support to meet the statewide criteria?
Your Honor, I would respectfully disagree with that, because it's not, that's the minimum, that is the minimum amount of host sites that are required to meet the statutory definition.
Did they require geographical dispersity between those 2 supporting sites?
I would say they do, based on the SMFP. And here's the other piece that we haven't talked about.
Did the application require as a condition that 1 be from the east and 1 be from the west?
Respectfully, Your Honor, that would be a statewide route. That would move from the east to the west.
I understand, but did it require that the 2 letters of support be geographically diverse?
No, Your Honor. The statutory definition, to your point, only requires that you have a minimum of 2 host sites. That's
And
correct.
they had those, correct?
Well, we contest one of them, but yes,
Right.
they had 2 left.
I guess what I was going to say is, when you're contesting because of the rescinded letter,
Yes.
that seems the opposite end of the spectrum of, we're talking about interpretation,
Right.
okay?
Yes.
That sounds like sufficiency of evidence. That doesn't sound like de novo review.
That's a fair point on the rescission letter, Your Honor, and that is an absolutely fair point on the rescission letter. But even the rescission letter has in its origin the agency's review, interpretation, and application of its own rule, 10A NCAC 0204, which is the rule that the Certificate of Need section utilized to disqualify this letter.
Then an applicant cannot amend this application.
That's it, Judge Tyson. That's
And that
exactly
doesn't
right.
also say that you can amend another applicant's application.
What that rule says, it is the shortest rule that any of us deal with in any of these, and it is a golden rule, Your Honors. I will just tell you, for representing CON practitioners for 25 years in this state, it is well known. We talked about, Judge Arrowood, that agency interpretations are upheld when they're continuously applied and consistently applied for many years. This agency, for its history, has always interpreted and applied Rule 204 to mean that an applicant cannot amend its own application. And that evidence is in this record. That came into record. What has never been done before this case is the use of Rule 204 to disqualify a letter. There's another problem with this, using Rule 204. The letter came from Caldwell Memorial Hospital and its CEO, Laura Easton, and she's not an applicant. Caldwell Memorial Hospital is not an applicant.
Who drew the letter?
Who drew the letter? I think the letter was drafted by the CON consultant for Mitnick.
So
Your
client drew the letter.
Your client drew the letter.
I think that's right.
And also drew a similar letter for Harris in Jackson County to
That's correct.
withdraw their support as well.
That's correct. That's correct. And that's, Your Honor, that's a fair question, and that's what the evidence shows. But the letter that Ms. Easton signed originally for them, well, guess who drafted that? Their CON consultant.
Well, that's the way it goes, isn't it?
That's my point. That's
But
the way it goes.
she also signed one for you as well.
She did.
So she was supportive of both your applications.
Well, that's correct. Originally she was, and she indicated at trial that Ms. Easton was a very credible witness at the trial. She said, look, I run this hospital out in Western North Carolina. I take my duty seriously. I need more mobile PET, right? And so the fact of the matter is, I want Mitnick to win. I'm a UNC hospital. But if they don't get it, I need more mobile PET. I'm going to be looking to whoever has that to get it.
Wasn't she also induced to sign the rescission based upon assertion that her hospital would become a partner with your company as well?
No, that is not correct, Your Honor.
Is
That
that
was
not in the record?
alleged. That was alleged but not proved. That is not what the evidence in this record shows at all. No, sir.
So what induced her to do it?
Well, what induced her to do it, I wouldn't use the word induced. Brian Dunn, who was the business arm of UNC Hospitals, and again, all the allegations are that Alliance is a bad actor and anti-competitive. This record shows Alliance had nothing to do with these letters, absolutely nothing. UNC, Brian Dunn went to go see Ms. Easton or spoke with her on the phone and said, I just want to explain to you, did you understand when you signed an agreement for our competitor that UNC was also going to be applying for this? She said, no, I didn't know that. I was unaware of that. Were you aware that Alliance actually is the person that is providing service to you right now? She said, I was confused about that. And she said, you know what, I'm going to withdraw this. And after she had done that, she said, is there any chance we can be part of the JV? And Mr. Dunn said, no, it's done. That's premature. That's not going to happen. And it never did happen, Your Honor. And all of that was brought into the light. All of that was in this record. It's in this record. The testimony shows that. So no, that was an allegation. And that brings me to this point. I'm running out of time, but I'm here to answer your questions, not to go through my outline. I think our briefs the briefs of all the parties are very thorough. So I'm glad to answer questions that you have. But I want to address this concern, this allegation from Insight from the very beginning of the case, starting with public comments, that Alliance Healthcare is somehow some type of bad actor, an anti-competitive actor. They said it in their public comments. They said, we're worried that they're going to do it. You know, now look, they did it in the rescission letter. We're going to have trouble getting host sites. Your Honor, what the evidence in this case showed that to be absolute malarkey. Pam Robinette was the representative from Insight, and Insight is not some tiny little company. They are a national imaging company, a huge company. And when this mobile PET hit the SMFP in 2018, they knew it was coming. Her testimony was, I started trying to get host sites in 18 months before this application was filed. And I said, what was your process for that? She said, I was going to go to existing Insight customers. I talked to 10 of them. I went to former Insight customers. I talked to 10 of them. I even talked to 4 Alliance customers, 2 of which were Harris and Caldwell. I also talked to large oncology centers because they might have need for a mobile pet. That's 26 contacts she made. She ended up with two potential host sites, and it just
But 2 was all she needed, is that not correct?
well, that is the minimum amount she needed to qualify for a mobile pet, Your Honor. That does not mean you satisfy the statutory criterion.
If you pass the bar, you pass the bar, right?
That's correct. No, it satisfies the definition of a mobile pet. All I'm saying is, I guess I'll get to this in my rebuttal. I do have a little bit more time. But when you only have 2 host sites and you've got a mobile pet and there's a statewide need determination, your projections have to meet the performance standard of 2,080 scans a year.
And this is 3 and 5 you're referring to.
That's correct, Your Honor, criterion 3 and 5. And this is a big point, because even if we throw out everything under criterion 1, throw out the rescission letter, throw out the fact that they misinterpreted statewide, under 3 and 5, this application is absolutely non-approvable. The projections utilized by their expert to meet 2080, when she ended up with just 2, and remember the evidence showed 9 days before the application, they had 6 hosts. Then 6 days, they had 4. And then only 3 days before, Ms. Robinette said, well, I'm really only going to have 2. And at that point in time, the application got goosed, all the numbers changed, all the projections went up. It is only because she projected 80 to 95% market share in 8 counties that she could make the numbers reach the 2080. And here's the most fundamental point, that was a fundamentally unreasonable and not supported proposition. The agency had in front of it this proposal. To reach the 2080, she said, well, I'm going to project Caldwell does 1,046 procedures a year. And I'm going to project that Harris does 1,080 per year. And that gets me to that. When the agency received that, it had a duty to analyze and test the reasonableness of the assumptions. The chart in the SMFP shows the utilization by every hospital of mobile pet in the whole state, okay? That is table 9M2 in the SMFP. There are 30 hospitals listed there in 4 years of data that those 30 hospitals have on mobile pet. Not a single one of those hospitals ever did 1,000 scans in a year. And,
Okay, on the trial ALJ's order on page 361 and 362,
yes, Your Honor.
he made 21 findings of fact concerning criteria 3.
Okay,
And they're listed there on 361, 362.
right,
Again, going back to our standard review.
yes.
If those findings are supported by substantial or competent evidence in the record, we're bound by those, are we not?
Well, if you apply the whole record test, you are, Your Honor, but
And would they not, is that not what you apply to findings of fact?
to findings of fact, yes.
So of the 21 findings of fact,
Right.
with regard to criteria 3, we're bound by the ALJ.
Your Honor, I am into my 5 minutes of rebuttal. May I have permission to answer your question?
Yes, if you would,
Okay.
please.
No, you're not bound by it, Your Honor, because the point that we're making with regard to those findings of fact is a regurgitation of what's in the required state agency findings, which does this. All it does is pick up on exactly the projections and the math that was done and resets it out in the findings and says it was reasonable. Saying it's reasonable, don't make it reasonable. If they were to look at one single piece of paper in the SMFP, they could have seen a multitude of reasons why those projections were not reasonable. They would have seen that no hospital in the history of our state has ever done more than 1,000 scans on a mobile pet in a year. They would have seen that the last number of scans done by Caldwell, remember, she projected Caldwell's going to do 1,046 scans a year so she can meet the performance standard. In the very last year reported in this SMFP,
What year was that, by the way?
16, Your Honor, 16. That's the last time the data was available, and it looks back to 12. The most amount of scans Caldwell had done was 70. 70. So the projection here by that applicant to satisfy the performance standard was 15 times the amount that Caldwell has done. And I'll sit down after saying, Ms. Houston talked about that. She said, no one asked me how much I might need. No one asked me how much I might have the budget for. No one asked me whether I could meet 95% market share. She said, I've been here 25 years as CEO. I have never had 95% market share of anything.
Thank you, Mr. Whitman. We'll reserve remaining time, and we'll give you a moment due to the court's questions. Thank you. Okay, we'll hear from the appellee. You have numerous counsel at the table. Do you plan to divide your argument, or?
Yes, Your Honor, we will. The two of us will argue, myself and Mark Hewitt.
So you're Mr. Hunter.
Yes, Your Honor.
Would
Derek
you-
Hunter from the Attorney General's Office, North Carolina Department of Justice, on behalf of the Department of Health and Human Services.
May proceed.
Thank you, Your Honor. May it please the court. I will begin, Your Honor, by stating that it is important not to conflate the terms need determination and service area. In its brief, Mobile Imaging Partners, which I will refer to as MIP, the appellant, and Mr. Whitman in his argument refer to a statewide need determination. Rather, for purposes of clarity, it is important to distinguish the terms of art because they are indeed distinct. A need determination is numerical. For example, as in this case, there was a need determination for one mobile PET scanner. Other examples of need determinations are one MRI scanner, 2 operating rooms, 50 acute care beds. Need determinations may be increased or decreased during the year based on the inventory, based on changes in circumstances in the inventories, including PET scanners. A service area, however, is not numerical. One cannot increase or decrease a service area.
And there are 6 in North Carolina, is that correct?
That is correct, Your Honor. The service area is geographical. It is defined. So, lest we confuse a statewide need determination, which does not exist, to mean that the service is needed in the entire state, which MIP alleges, I submit to the court that this distinction must be drawn for a clear understanding of the need determination and a statewide service area to remain consistent with the statutes, policies, and rules that govern the Certificate of Need law.
I asked Mr. Whitman if the number of locations and number of PET scans had grown over the 16 years between the 2002 and the 2018 state health plan.
Yes, Your Honor.
And he said that they had. Is it, and I won't, maybe, if this is your area or the other area, you can defer if you want. There's a 3-year forward projection of the number of PET scans, correct?
Sure, yes, sir.
So does the application have to be forward-looking so that it's not just what is here today, but what will likely be there 3 years out in order to satisfy the con?
Yes, Your Honor, you are correct. An applicant is required to project utilizations to meet the performance standards in order to be found conforming.
And the applicant would be able to not just say what's there today, but what is likely to be there 3 years out.
They would have to project that, Your Honor, and their projections have to be reasonable and adequately supported to be deemed conforming by the CON section.
And is it reasonable for the Health and Human Services to presume that once the con is issued, that provider will be seeking additional sites once they provide the service?
Well, certainly in the instance of PET scanners, that would certainly be reasonable, Your Honor. One of the examples I think that was given, and you may have referenced that earlier when Mr. Whitman was arguing, is that one of the Alliance scanners was originally approved for 3 host sites. It now serves 18 host sites, none of which are the 3 that it was originally approved for. So it is absolutely reasonable to project that once a PET scanner comes online, there will be numerous additional host sites added to its service.
I referred to the ALJ on page 261 and 262 of his order,
Yes, Your Honor.
and I wanted, one of those findings says this, that sorry, give me a moment. Physicians are using PET scanners for an increasing number of health conditions, and Insight's assumption was the demand for PET services would increase in the future.
Yes,
Is
sir.
that based upon substantial evidence in the record?
Yes, Your Honor. It's based on substantial evidence in the record as well as the projections of of all of the applicants actually in this review. PET scanner is used to, it's mainly used to diagnose cancer, but certainly if you think about the overutilization of the two Alliance scanners, the ones that serve West and East, or, well, they're statewide now, but Your Honor, if you think about how those scanners operate, and you think about the limited amount of time the scanner is able to give to each host site, if another scanner comes online, and particularly based on the projections of Insight in this particular instance, if that particular scanner is allowed to only serve, or if it only serves 2 host sites, that means that is a ton more scans that would be done at those particular host sites than is currently capable with the 2 Alliance scanners.
Your friend, Mr. Whitman, argued that the need determination or the projection was unreasonable because it was 15 times the scans that had been done the previous year at Caldwell. You want to address that?
It harkens back to what I just said, Your Honor. If you place a new scanner online, that scanner would be able to serve, particularly in this instance, Caldwell and Harris. It would be able to perform far more scans than it has done historically, because based on these projections, those are the 2 host sites that scanner would serve.
So is it your argument that, this 15 times what Caldwell has done in the past, it seems a little circular in the sense that you're saying, well, there will be other hosts. Everyone will be wanting to use this because it's available, but it wouldn't be at Caldwell. Like there wouldn't be 1,000 uses at Caldwell.
That's perhaps true, Your Honor, but all the applicant is required to do is make projections that are reasonable and adequately supported based on the methodology it uses. And in this particular instance, the agency found that Insight used a reasonable and adequately supported, well, its methodology was reasonable, and the projections that it produced were adequately supported based on its methodology.
And the appellant used a different methodology in their analysis, is that correct?
Yes, happens all the time. And the CON law does not dictate which methodology must be used. There are numerous methodologies that can be used. It's just that whatever methodology the applicant uses, it must be reasonable and adequately supported based on that particular methodology.
And how does the agency go about selecting which methodology is reasonable and?
The agency does not select. The applicants select whichever methodology they want to use. The agency then reviews the methodology chosen and the projections to ensure that they are reasonably and adequately supported such that they conform with the criteria.
You would agree there has to be a factual basis for those assertions, would you not?
Yes, Your Honor.
And you would have to agree that the methodology they use would have to have some basis in fact.
Yes, Your Honor.
So your friend is arguing that it's unreasonable to believe there'd be a 15-fold increase in the number of PET scans at Caldwell over their last known usage. I mean, are we bound by that determination?
Are you bound by which determination, Your Honor?
By the fact that the agency found that projection to be reasonable and the methodology they used to promote it.
Well, what this court is required to do, Your Honor, based on the standard of review, is to determine whether or not there is substantial evidence in the record, in this entire record, to support the agency's findings, well, the ALJ's findings, which upheld the agency's decision. Now, I would defer for any specifics regarding the methodologies used to my counsel, since it's his client and they were the ones who developed the application. But this court is bound by the determination based on the whole record test that as long as there's substantial evidence in the record, that should be upheld. I will also address now this issue about, I will go back to the issue about a statewide need determination, or what the agency meant by statewide and how it should be interpreted. Contrary to MIP's argument, the statewide service area does not mean the scanner is required to serve host sites throughout the state or everywhere in the state or the entire state. In fact, it was in the 2018 SMFP that the State Health Coordinating Council recommended that the service areas for PET scanners, which used to be east and west, be made statewide. And the language that it used specifically was The east and west service areas should be converted to a statewide service area, quote, to allow flexibility in servicing mobile pet sites. It did not say that statewide meant it had to provide services throughout the state, everywhere in the state. It changed the service area specifically to make it more convenient for the pet scanners to move.
So would Insight be free to solicit business under this con anywhere within North Carolina?
Anywhere within the state. That is what statewide means. Ms. Frazzoni testified, who was chief of the agency, who assisted in drafting the language, that statewide meant anywhere in the state. Now, prior to the 2018 SMFP, there was no statewide service area for pet scanners. So this was a matter of first impression. So this court then would give heightened deference to the agency in its interpretation of its own rule or its own term.
Were they designated by the 6 service areas that the department set up?
I'm sorry, say again, Your Honor?
Again, I understand there are 6 healthcare districts
Sure,
throughout
6
the
health
state.
service areas, that's correct, Your Honor.
And is it correct they were doing need determinations within each of those districts at the time?
No, Your Honor. The need determination, again, is numerical. The need determination is 1. The service area is statewide. And what that means is the service provider can provide services anywhere in the state.
Let me put it another way.
Yes.
Is there a geographical determination in the need?
In this particular need, well, yes, Your Honor, there is a geographical component. In this particular instance, that geographical component is statewide. Consider statewide to be like, even any of your health service areas, consider them to be like a fence. As long as you provide services somewhere within that fence, or to say it another way, you are allowed to provide services anywhere within that fence.
So I can pick
Same
up,
rules apply.
I can pick up my law license and I can go anywhere within the 100 counties of North Carolina.
Yes, you can.
But it's one law license issued by the state.
Indeed it is.
But it goes anywhere to the 100 counties.
Murphy to Manio. Yes, Your Honor, you're absolutely correct. Same with this PET scanner, anywhere in the state, from Murphy to Manio. But you're not required to serve any particular area. You're allowed to serve any particular area.
And before this was changed, you were allowed to serve either eastern North Carolina or western North Carolina with PET scanners. Is that how it was done? Or?
The service area before this one was east and west. And you say you're served, it's only 2. Alliance had both of those PET scanners. They've enjoyed a monopoly on PET services since 2002.
Except for Novant.
With the exception of Novant that came online in 2017. So let me put it this way. Other than a Novant hospital, any hospital or physician practice group in the state of North Carolina that wants to provide PET services to its patients has one option: Alliance.
Well, let me back up on that a minute, because there are dedicated site PET scanners within each teaching hospital in North Carolina.
That is correct.
At Duke, at Wake Forest, at Chapel Hill, at East Carolina. Every one of those has one, right?
That a lot of them do, yes.
So what you're talking about is mobile.
Yes, indeed.
I wanted to clarify that because there are PET scanner opportunities that are in place at all the major hospitals.
Major hospitals, yes.
So the point of this is to give that service to remote areas that don't have them?
Well, certainly one big fundamental purpose or premise of the CON law is to make sure that services are provided in rural areas, areas that would not otherwise have access. So you take a case like this with a mobile PET scanner, that scanner can go out to Jackson County, it can go out to the coast, and that allows the convenience for folks who don't live near a UNC hospitals or a Rex hospital to also have access to PET scanner services.
You're about halfway through. I just wanted to kind of keep track on your time.
Thank you, Your Honor. And I will be, let me just touch on this portion before I yield to my co-counsel. The term statewide is not a statutory term, as alleged by MIP. It is a term contained in the SMFP. The SMFP is not a statute. And by statute, the SMFP is not a rule. So the agency, in coordination with the State Health Coordinating Council, is entitled to heightened discretion in its interpretation of the term statewide.
What is your what's your underlying basis for that your authority for that it's the heightened deference?
The fact that, well, Your Honor, as I think two of you, I think both you and Judge Tyson have already stated, there is deference entitled to the agency for statutes and for rules. Well, certainly for an instance, in this particular instance, neither statute nor rule that the agency itself drafted, it would be entitled to deference, of course, for a term that it itself.
And what?
So-
And my question is, and I think I probably wasn't clear. What can you point to that says that?
That the agency is entitled to discretion in interpretation of its own
That
rules?
it's high, that it's entitled to high deference with respect to this. Since you say it's not a rule and it's not a statute, how do you get to high deference?
I understand. Let me withdraw the word heightened. The agency is certainly entitled to deference in interpretation of its own rule.
Is the state health plan, is that a rule or a regulation by the agency?
The state medical facilities plan is not a rule. As a matter of fact, North Carolina General Statutes 150B-28AK, which is cited in our brief, states specifically that the SMFP is not a rule.
Okay.
And if you all have no other questions, I will now yield to my learned co-counsel, Mr. Hewitt.
Thank you, sir.
Thank you, Your Honor.
Mr. Hunter.
you.
Mr. Hewitt?
Thank you, Judge Tyson. Good afternoon. I'm Mark Hewitt, and my partner Elizabeth Hedrick is with me this afternoon. We're from the Fox Rothschild firm. We're counsel for Insight Health and Wake County Bar. If it please the court, Your Honors, just one point of clarification. I think there were some questions earlier about the 6 defined health service areas within the state and how that relates to the service area that relates to any given need determination. I just wanted to clarify that the state medical facilities plan does define 6 multi-county health service areas within the state, but none those geographic definitions do not apply to this review, did not apply to this need determination.
Are they mostly applicable to fixed facilities?
It depends on the particular service, Judge Tyson. Some types of
Hospital
services are
beds.
subject. They can be, but not always. Frequently, service areas are tied to a given county. Sometimes groups of counties, sometimes one of 6 HSAs, sometimes as big as statewide. It just depends on the service. I would encourage you, to the extent there's any confusion, look at Documentary Exhibits, page 407. And that is a table, which is a page from the State Medical Facilities Plan, which identified the need determination that is the subject of this appeal. And under one column, even though Mr. Whitman for MIP consistently referred to a statewide need determination, there was no such thing. What you can see on that page is a need determination for one, as Mr. Hunter said, mobile PET scanner, and the service area that's defined in connection with that need determination is statewide. That term, statewide, does not appear in any statute, nor does it appear in any rule. It is only in the SMFP. And to your question, Judge Arrowwood, what gives the agency discretion? Why is this not subject to any different type of review as opposed to a rule or a statute? Well, GS 177 empowers the agency to administer the CON program. And one of the functions that the agency is empowered to do is to draft a state medical facilities plan. So the agency, along with the State Health Coordinating Council, is by statute given the discretion and authority to draft the very document that the term statewide comes out of. Now, I do want to turn briefly. As you already know, Alliance had an effective monopoly on mobile PET services in North Carolina for almost 20 years.
But for the Nuvant.
I said
for the
almost.
Okay, thank you.
Effective monopoly. Yes, ma'am, Judge Inman, because unless you're Novant, as Mr. Hunter pointed out, unless you're Novant, your only option as a hospital or physician practice that wants mobile PET in the state of North Carolina is to negotiate with Alliance Imaging. It's been that way for almost 20 years. And so in this review, the agency...
But they're competing also with fixed units as well, correct?
Sorry, sir?
Alliance is also competing with fixed units in the hospital.
They are, Your Honor. And some, as you correctly pointed out, some hospitals and some locations do have fixed PET. However, mobile PET is a service that is regulated separately and is separately the subject of its own need determinations and its own CON reviews. And what the evidence in this case developed, that the two Alliance scanners are doing, even though they are mobile and not fixed, are doing leaps and bounds more scans per year than almost any fixed scanner in the state. It's a different animal. And in this case, the agency recognized when it made this need determination in 2018 that there is a need, that competition is a very important factor for the purposes of this CON review, and accordingly, they included the addition of a new provider, a competing provider, as one of the factors in their comparative analysis. And
Well, Alliance certainly would have been entitled to the con if they had chosen, I mean, they were not excluded from this application process.
Certainly not, certainly not. And their subsidiary entity, MIP, in fact applied. And they complied with all of the review criteria. The only reason that MIP didn't get it and Insight did was because of the comparative analysis. And based on the factors that the agency weighed in that comparative analysis, Insight came out ahead on 2 factors, whereas MIP and Novant, Novant, a third applicant, each tied at 1 factor each.
Is that a subjective process?
I think it probably could be considered subjective by the agency. It's a discretionary weighing of comparative factors.
And
But
how
that's
do
their job.
do we give deference to that subjective determination?
Absolutely, Your Honor. And I will point out that MIP did not challenge the outcome of the comparative analysis in this appeal. They challenged it at the trial level, but they did not do that on appeal. And so, but the case law from this court is well settled that the agency has broad discretion to choose and weigh comparative factors.
But and it sounds like you're saying that one of the comparative factors literally is competition?
Yes, ma'am.
And that having a different provider than MIPNC, MIP-NC, was an advantage to Insight in the comparative analysis.
It was, Your Honor, but I'll also point out that one of the other comparative factors that was used in this review was geographic coverage, geographic scope. I can't remember the exact name of the factor, Your Honor, but MIP actually won on that factor because they had more
Well, they did,
sites
right.
in more different places. So they got credit for having this broad array of host sites in their statewide route, quote unquote. But that wasn't the end of the analysis. That factored into the bucket with all of the other factors, and Insight still came
I
out.
see.
So even if we disqualified Insight's application for lack of criteria, lack of statewide, it doesn't mean necessarily that Allied would get the con. You go back to Novant, even if your client's con application was disqualified, right?
I don't think we can say for certain whether Novant would have gotten it over MIP, but at trial, MIP had to demonstrate that they would have been next in line if Insight had been disqualified, and they didn't do that. That was one of the things that the ALJ made.
That's what I'm referring to. So basically, even if your client was application was disqualified by the rescission of the Caldwell site, the department would have to go back and then look between Alliance and Novant, correct?
That's exactly right, Your Honor. But the court doesn't even.
I guess say it another
reach
way,
that
both of them submitted conforming applications.
All three.
All 3 did.
Insight, Alliance, and Novant. Yes, sir.
Excuse me if I missed this before, but what is the authority that you're citing for this criteria of competition in the
That
comparative analysis?
As a matter of semantics, Your Honor, competition wasn't a criterion. The review criterion or criteria are statutory.
Right.
Those are 131E-183A.
Right. And competition isn't in there.
Actually, it is. Review criterion 18A.
Okay.
Requires every applicant to demonstrate the effect that their project would have on competition.
Is there a preference for
I
multiple
see. Okay,
providers?
so it's a negative inference in a way. Well,
That might be over.
Okay.
I don't know that I would generalize it quite that far.
okay.
Let me ask you this question to follow up on hers.
Yes, ma'am.
Is multiple providers preferred to a single source provider?
I think so, Your Honor. It doesn't say it in so many words in the CON Act, but the CON Act by statute, as we were just talking about, contemplates that applicants have to demonstrate how they are going to enhance competition, for example. And the agency recognized here that there was a lack of competition. And as Judge Arrowwood's questions pointed out earlier, Alliance is the sole member of MIP, and it's structured in such a way that the JV partner, UNC Rockingham, will only get an interest if they get the CON, and even then, as the ALJ's findings of fact determined, UNC Rockingham will only have minimal responsibilities. Alliance will continue to manage the unit. Alliance will staff and transport and operate the unit. Alliance will negotiate the contracts with host sites, and critically, the application even says that the proposed PET scanner's route and schedule will be coordinated with the route and schedules of the two Alliance scanners. So if you're a new hospital in North Carolina that wants mobile PET services, you have to pick up the phone and negotiate with the very same Alliance that controls the only two other scanners, unless you're Novant, in the state. That's not enhancing competition. All that does is strengthen Alliance's stranglehold on the market. Now, if I may, I want to turn very briefly to the standard of review, because I do think MIP was consistently arguing the wrong standard of review. Under the whole record test, as you know, the court doesn't substitute its judgment for that of the agency, even if there's contradictory evidence, or the court would reach a different outcome on its own.
Is our standard of review the same as the ALJ?
The ALJ is to give due regard to the agency's determinations at the trial level, Your Honor. It's a different statute. This court is bound by 150B-51, as you know. So the decisions are a little bit fuzzy on exactly whether it's the same standard of review or very similar.
Well, questions of law of de novo.
Yes, sir.
And questions of fact or whole record test. Is
Yes, sir.
Is that equally applicable to both the ALJ and this court?
I think so, Your Honor. And I think the ALJ's decision reflects that, Your Honor, because the ALJ made detailed findings of fact as to the bases for a lot of the projections and that sort of thing, but in its conclusions of law, the ALJ's findings generally followed the pattern that the agency acted reasonably and did not err.
So back to the statewide, the interpretation of the word statewide,
Yes, ma'am.
which you've pointed out isn't in the statute. It's not a statutory interpretation. Because normally when we think of interpreting words in a statute, it's de novo. It's de novo.
Yes, ma'am.
And your argument is your argument that this isn't in a statute, it's part of the agency's determination. The agency has come up, it's not even a rule.
That's
Right? It's an agency term of art, and therefore it's not de novo review of legal interpretation.
I think that's exactly right, Judge Inman. And I will, I'm heedful of MIP's counsel constantly referring to the review criteria, referring to the CON Act, and having to comply with the statutory review criteria. But think about, what is the term that we're fighting about? It's what does statewide mean? Not what does conformity mean, not what does need mean, it's statewide. And statewide's not in the review criteria, it's not in a rule, it's only in the SMFP. And that's why we say this was an exercise of the agency's discretion and not a decision of law. Okay. And I want to turn, if I may, to the criterion 3 arguments. I'm short on time. MIP's counsel argued these statistical reasons and said if you just looked at one page in the SMFP, the agency would have known that Insight's utilization projections were unreasonable and that sort of thing. But Judge Tyson, as you pointed out, there were 20 pages in the Insight application of bases for Insight's utilization projections, and 2 pages of findings of fact in the final decision, where the ALJ explained the basis that Insight's projections relied on. And MIP basically just disagrees and says that stuff doesn't matter. You really should be looking over here at these metrics we want you to look at in the State Medical Facilities Plan. But as you know, substantial evidence in the record is all that is required, and it doesn't matter under the statute, under a standard of review. It doesn't matter if there's contradictory evidence in the record. And I will point out that despite all the argument about errors of law and the ALJ disregarding evidence, this court has recognized that those types of arguments amount to arguments about the sufficiency of evidence, and therefore the whole record test applies. The East Carolina internal medicine case that was cited in MIP's reply brief actually goes to that direct point. And in that case, the petitioner, ECIM, argued that the ALJ failed to make findings in accordance with the undisputed record evidence. And the court said, quote, "It is really arguing that the department's decision was not supported by the evidence or was arbitrary and capricious, thus triggering application of the whole record test." And so we've covered a lot of ground, Your Honors, and if I may just, I'm out of time, but
I'll give you a moment to sum up.
all I have to say in conclusion, Your Honors, is that MIP cannot prevail on this appeal, simply because its arguments are simply disagreement with discretionary determinations by the agency, not only about the meaning of statewide in the SMFP, but also conformity determinations based on its evaluation of projections and assumptions in the Insight CON application, all of which are within the agency's statutory authority and all of which are subject to the whole record test and supported by substantial evidence. And I really didn't get to talk about it, Your Honors, but I will say that the rescission letter that MIP's briefing talks about so much was just an anti-competitive attempt to sabotage Insight's application and preserve Alliance's monopoly on mobile pet services, which the agency considered but rightfully recognized didn't move the needle on the fact that Insight documented interest from two host sites.
What would you have the court to do?
I would have the court uphold the agency's and the ALJ's decisions, which were well-reasoned and based on plenty of substantial evidence, Your Honor.
Thank you, sir. Rebuttal?
Your Honor, I don't have a lot of time, although I think you're going to give me a minute or two more.
Mr. Whitman, we said we'd give you some discretion to make up for the court's question on your,
Yes, sir.
on your main
And
argument.
I thank you for that, Your Honor. And I'll pick up right where my colleague, Mr. Hewitt, left off. Respectfully, Your Honor, this court has to reverse this decision. If it does not, it will encourage every healthcare planner from this point forward on a statewide determination, service area statewide, to do what? Apply for the fewest statutory amount of host sites possible, put them as close as they can be together in one portion of the state with the lowest amount of costs so that they stand to win the comparative analysis. And that is bad health policy. That is bad health planning. What is the Certificate of Need law's core foundational principle? Geographic access to service.
But we're not making a policy determination here, are we? We're determining whether or not the ALJ erred in what
Right.
he did.
I agree, Your Honor, but this is part of why he erred. If you read that final decision, which is only 31 pages, and we tried this case for 2 weeks, 2 weeks we tried this case, you would never know these issues about statewide were in the evidence because he doesn't deal with them. And they are important. And that's why the agency doesn't get deference, and this is why they got it wrong. Now, very briefly, I want to talk about the Novant issue, Your Honor. I completely disagree that if Your Honors disregard the Insight application or found them non-conforming, as you should under 1, 3, or 5, we do get the CON. Novant also appealed this decision. We alleged in our petition that we were comparatively superior to Novant. Then what happened? Novant took a voluntary dismissal with prejudice. They're out. So both parties appealed, but only one party preserved its property interests to the CON, and that was Mipnick. You don't have to prove evidence in a trial when there's an empty chair and someone voluntarily relinquished their rights. They waived any potential ability to get this CON. So that issue is incorrect, and if we succeed in getting a reversal here, the Certificate of Need will and should go to Mipnick, which has what? A statewide route, which has 9 host sites, all in rural areas.
But which is also the only person other than Novant who does this in the state. Is that not correct?
Well, yes and no, Your Honor. I'm not trying to disregard the fact that Alliance has a major portion of this JV, but as has been the strategy of Insight from the beginning, they want to call it Alliance. They want to ignore the role of UNC hospitals in this JV. It is important to UNC Rockingham, as the evidence in this case showed. And ultimately, Your Honors, and I'll just use my extra time to to address this final point, if I could, Your Honor. Mr. Hunter stood up here and said there's a difference between a need determination and the service area. And the need determinations can be changed, but service areas can't. Well, Your Honor, respectfully, and Derek is a good friend of mine. We get on just fine and have been in many cases together. That's not true. The service area here could have been HSA 1. That's where their proposal is. If that's where the need was, it could have been HSA 1, 2, and 3. It wasn't. It was statewide. And if, using their own words against them, if truly what the SHIC was trying to do by eliminating service in only the western part of the state or only the eastern part of the state, one of these two applicants did that, and that was Mitnick. Their application doesn't do that. It sits in the far western part of this state. It does not satisfy the performance standards based on the objective data that was available to the agency.
How do you respond to your friend's argument that you're not challenging whether or not the application was compliant with the request, with the con request? The agency determined that all three or all four applications complied.
3 of the 4.
Right, and you have not challenged that compliance, correct? Or would you like to refute what they said?
Oh, no, we absolutely challenged it, Your Honor. I mean, we challenged our position at the trial, and again, here before you today, is that this court should find, based on the record that was presented at the trial, the evidence that was admitted, that Insight's application was non-conforming with statutory review criterion 1, 3, and/or 5.
Only because of the rescission?
No, not at all. The rescission is just an additional basis to find them non-conforming. And that's why I said the rescission letter got a lot of attention in this case, but the most important issue, and I'm glad you brought this up, Judge Tyson, if I could have leave of court to explain this.
Just very briefly.
Because this goes to our de novo argument that it is a statutory interpretation. Mr. Hunter and Mr. Hewitt did their best to deflect the court's attention from this. We say they're non-conforming with criterion 1. Forget about the rescission letter. Because why? Because a proposal to serve only 2 rural hospitals in the very far western part of the state does not address a statewide need determination. What does criterion 1 say? That's statutory. That's 131E, 183A. What does it say? It says this.
But we would have to agree to your argument on statewide in order to do that, correct?
You would. You would, Your Honor, but that's, again, for all the reasons that we've briefed and I've argued, this is what criterion 1 says, and that the agency had to assess conformity and the ALJ had to assess their assessment of conformity. Criterion 1, the proposed project shall be consistent with what? Applicable policies and need determinations in the SMFP. So you go to the SMFP in this case, Mr. Hewitt cited to it, it's supplement 9D, page 1635, it's this one page. What does the SHIC tell us? The need determination here is that there's a need for 1 additional mobile dedicated PET scanner statewide. It is determined that the service area listed in the table below needs additional PET service. What is that service area? Statewide. It's not HSA 1, it's not Western North Carolina.
It was a listing
It's
of 30,
statewide.
a listing of about 31 hospitals, correct?
That's
Is what
correct.
that was.
Thank you.
What would you, I'll give you a minute. What would you have the court to do?
What I would have the court do is find the Insight application non-conforming on statutory criterion 1, 3, or 5, because it only takes 1. And there's grounds to do it all 3, but if you find they're non-conforming with criterion 1, 3, or 5, declare that the application should have been non-conforming and enter a ruling that the certificate of need for a statewide mobile PET CON be issued to Mitnick.
Thank
That
you,
the court has that authority.
Thank you.
Thank you.
We appreciate good arguments from both counsel. Mr. Soar?
All rise. This session of the North Carolina Court of Appeals is adjourned.